So without further delay, I'd like to introduce our first speaker. Dr. Steve Halbrook is a research fellow here at the Independent Institute. He received his JD from Georgetown University Law Center and PhD in social philosophy from Florida State University. He's taught legal and political philosophy at various schools, including George Mason University, Howard University, and Tuskegee Institute. He's the author of many other books. He's the winner of 3 Supreme Court cases, which I won't list. You can ask if you're interested. And it's a real pleasure to work with Steve, who's really proven that truth can prevail. Steve?
Thank you, David. Thank you all for being here. It's a real pleasure. This is so deja vu. Like 2 years ago, we did exactly the same thing after the Heller decision. At that time, the Founders' Second Amendment had come out, and a lot of the research that went into that book had been published previously, originally in my book, That Every Man Be Armed, and then in other publications. And then the Supreme Court in the Heller case made good use of that research. One thing that I started doing as an undergraduate was reading the Reconstruction Amendments debates. After the Civil War, Congress passed the 14th Amendment and other amendments, and it had to do with making sure that newly freed slaves, African Americans, had all the same rights as everybody else, because under slavery they were not allowed to possess guns, to engage in free speech, to assemble or do any of the other things that citizens are allowed to do. And after the Civil War, the southern states passed the black codes, which tried to maintain the same kinds of laws. And so I started studying that. That was in the late 60s. And eventually, I published some law review articles on it, the fact that the 14th Amendment was intended to bring complete freedom to former slaves, including the right to keep and bear arms, and that states and localities could not infringe on those rights. Back in 1989, California passed the first so-called assault weapon ban in U.S. history, or it's basically a rifle ban, and the Roberti-Ruiz law. And I brought a lawsuit out here called Fresno Rifle and Pistol Club contesting that case. And we had a lot of the same research that ended up in this book, Securing Civil Rights, and also ended up in the Supreme Court decision that was just announced last month. Going back to the period when I argued that case in the early 90s in the U.S. Court of Appeals for the Ninth Circuit in San Francisco, the 3-judge panel, they were skeptical about that. We had a press release after that argument, David, if you remember, and we got an adverse decision saying that, well, nobody really knew what they meant by the 14th Amendment, or whether the Second Amendment was supposed to be applicable to the states through the 14th Amendment. And they basically poo-pooed the idea that the Second Amendment applied in the state of California. So then we come forward, and you'll hear more about this. Don Kilmer's had a case going for some time now that actually resulted in the Ninth Circuit holding, I guess it was a year ago or 2 years, I'm losing memory, 1 year. And they flip-flopped and reversed themselves from the case that I had. I mean, what was wrong with me? They rule adversely to me, and then Don, the hair. Whatever. They say, yeah, we agree with you that the Second Amendment applies in California. But a lot of water had crossed the dam. One thing I did, though, after they ruled against me in my case, was I did get revenge. And what I did, I had been working up these materials on the historical meaning of the 14th Amendment, the intent to incorporate the right to keep and bear arms. I published in law reviews a number of articles, and then I published in 1998 the book Freedmen, the 14th Amendment, and the Right to Bear Arms. And that's the book that's here tonight. There's a new title to it, Securing Civil Rights. And the way I got revenge was by first writing the book, and then the Supreme Court using that book as the main historical basis, or a major historical basis, for the historical discussion in the McDonald case. If you read the McDonald decision, you'll see not only the book cited, but you'll see a lot of the same references and speeches that are in the book, citations to those speeches and references, and and I'm proud to say that I was the first one that found those references. So that's how I got my revenge against the judges who ruled against me, and also against the California so-called assault weapon ban, which I hope will come under increased scrutiny now, because it's an affront to your rights in this state that they could ban ordinary rifles, the AR-15, very fine rifles like that are commonly possessed by law-abiding people throughout the rest of the United States. One of the things that Heller decided 2 years ago was that the test for whether a firearm or a weapon is constitutionally protected is whether it's commonly possessed by law-abiding people for lawful purposes. And you see AR-15s in every shooting range in the country except for California, New Jersey, one or two other places like that. You know, I wouldn't live here. I love your state, though, and that's why I've done all I can to try to help you. My wife's originally from San Francisco, and I told her, I'm not moving there. You got to wait till I die, because they don't like my guns in that state. I guess I should tell you a little bit more detail about the McDonald decision. It was written by Justice Alito. It's a very well-done opinion, basically holding that the due process clause of the 14th Amendment makes the Second Amendment apply to the states. And what that's about is the 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of law. And over time, the Supreme Court has said that that means that they can't take away your right to free speech, your right against unreasonable search and seizure, things like that. And now at this late date, finally, they've gotten around, after about a century of those kinds of cases, to saying that also the Second Amendment is protected through the Due Process Clause. In other words, you have a right to life, liberty, and property, and they cannot take those rights away without due process, and it would violate due process to ban free speech or to ban the right to keep and bear arms. Just a couple of issues that are going to come up, or that really have already come up, and there's some, I think, hidden messages in the opinion of the court for us. The very first statute that is talked about in the McDonald decision to illustrate what was had in mind leading to the adoption of the 14th Amendment was a Mississippi law passed in 1865 saying that basically African Americans could not keep or carry any firearm without a license from the local governing body. It was not a complete ban. You had to have a license. Does that remind you of anything? Hello? For mere possession or to carry it. Now, most states require a license to carry, but let's focus on keeping for a moment. A license to keep. Hey, that's kind of like a registration system, isn't it? That's what they have in Washington, D.C. That's what they have in Chicago. Despite the victory in McDonald, the registration systems were not at issue. Now, the other side in McDonald argued in favor of Chicago that, for example, besides gun bans, registration is a great thing. There's a long tradition in England of firearm registration. That's right. In 1660, Charles II decreed that gunsmiths, gun makers, had to report all the names of people they sold guns to. And then in 2 years later, 1662, they gave authority to all the lords lieutenants, those were basically state troopers of their time, that they could go and search and seize arms from anybody who was not considered loyal to the crown. So yeah, England had this history of violating the right to keep and bear arms. Chicago cited that for an example of how we have this long tradition of regulation. Yeah, the slave codes were regulation as well. And D.C., back in the Heller case, when it was being litigated, they bragged about how D.C. has long time had regulations for firearms. And their first regulations were passed in, I think, 1802, and it banned African Americans from having guns. So it's a sign of, I think, times to come. There was more than one reference in the McDonald opinion to the fact that you had to have a license from somebody to possess or to carry a gun. So that's a word to the wise. If you're those of us who are litigating issues like you can't get a license from the sheriff to carry a concealed weapon, for example. Well, it's right out of the McDonald opinion. This is something that's a carryover kind of law from the black codes. And another good example, one of the references in McDonald is to a report of the executive branch, and it was talking about the fact that in Louisiana, right after the Civil War, there were these peonage contracts. The people who had been slaves were now peons, and they would be allowed to live on the same plantation as before. Housing would be provided, and there were certain rules. One of the number one rules was no guns could be possessed. Now, what does that remind you of today? Public housing. They provide you with the housing, and if you accept it, you can't possess any guns. San Francisco had a public housing ban. It was just done away with about a year ago based on a lawsuit filed right after Heller. The District of Columbia continued to have a public housing ban. And they're really all over the country, even in states that recognize the right to keep and bear arms by their state constitutions. We're fighting one of those bans in the state of Delaware, for example, right now. So that's another example of how, if you look at what was actually in these black codes that the Supreme Court said the 14th Amendment protected people against, you'll see that some of the same things reappear today, and I think there's meat there for litigating cases today on the same subjects. Now, I mentioned the holding of the court that the right to keep and bear arms was protected through the Due Process Clause of the 14th Amendment. That 4 justices agreed with that. Justice Thomas, who made the 5th vote in this case, would have grounded the applicability of the Second Amendment to the states under the Privileges or Immunities Clause of the 14th Amendment. Not something you hear much about. What are privileges or immunities? And the 14th Amendment says that no state shall deny any person the privileges or immunities of citizens. And back when the 14th Amendment was first proposed in the Senate by Senator Jacob Howard, he referred to rights, privileges, and immunities. And then he said that the provisions of the Bill of Rights, he didn't say every one of them, but he said all the important ones would be protected. And he went on to read the ones like the First Amendment, the Second Amendment. Whether you get a jury trial in a civil case if there's more than $20 at stake, the Seventh Amendment, that's not necessarily a fundamental right, because Jacob Howard talked about the kind of rights that don't exist under tyrannies or enslaved societies. And so if you don't have that Seventh Amendment right, I don't think that's an indication that you live in a slave society or a tyranny. But if you don't have a right to keep and bear arms or to assemble, you do have elements of those kinds of societies. So he actually distinguished between rights on the one hand and privileges or immunities on the other. And it's a very intricate legal doctrine. There was a lot of support for shifting from due process to privileges or immunities as the basis for incorporation of the Bill of Rights. And I probably shouldn't talk about it anymore because it's something that if you're really into that historical scholarship, it's going to be very important. But if I go into it in more detail and keep referring to these privileges or immunities, then I might lose some of you. Let's go on to something more exciting. Justice Scalia and Justice Stevens, they had it out one last time. Justice Scalia wrote a concurring opinion where he said that I agree with everything in the majority opinion or in the opinion of the court, but I'm really going to get Justice Stevens one last time. He's about to retire, and he really deserves it. And basically it had to do with this. Justice Stevens wrote a dissenting opinion that was I won't say out of la-la land because I'm trying to be polite here, but it's like enumerated constitutional rights don't really matter very much. The right to keep and bear arms, oh, come on. Like, who would believe in something like that? The Constitution protects personhood. When I start hearing this kind of thing, I'm thinking Hare Krishna time or something. It's like are you in touch with the cosmic consciousness of the universe and things like that? Because that's the kind of rhetoric that you see in Stevens' opinion. Judges, of course, are the ones who determine whether you have rights, and they look at these concepts that they make up as to whether you have these rights. So Justice Scalia said, this is meaningless. If it's in the Bill of Rights, it's explicitly protected. How can you deny that? and make up all of this other judicially created doctrine. So that's a great debate, the Stevens Scalia debate. Justice, one more point about the opinion, and then I want to mention the dissenting opinion. The court in Heller said twice that the Second Amendment is a fundamental right. If a right is fundamental, it means that it's a really serious right and judges should take it serious. And instead of me talking about what's called the strict scrutiny doctrine, I'll just put it that way, that we really mean it. It's a real right. Hello, so respect it, okay? And but they only said it twice. That wasn't enough. So you've got all these lower courts after Heller in various cases that are brought challenging different gun laws, saying that, well, yeah, they said fundamental right twice, but they didn't really mean it. So Alito, when he wrote the McDonald opinion, I didn't count how many times he said it, but I hope it's enough now. It's at least a dozen times. He said, well, to the Blackstone said it was a fundamental right. The colonists agreed with that. When the Bill of Rights was proposed, they thought it was a fundamental right. When they adopted it, they thought it was a fundamental right. After that, in the antebellum period, they thought it was a fundamental right. When the 14th Amendment, well, actually, the abolitionists thought it was a fundamental right. During Reconstruction, they thought it was a fundamental right. And even today, because of the fact that majority of states filed an amicus brief in this case in support of Second Amendment rights, and because of majority members of Congress, that it's even perceived to be a fundamental right in our country. So you could do a word search on your computer and see how many times they said it, but it's like, have we said it enough now that it's a fundamental right? Do you get it to the lower courts? And that's a very important aspect of this, because if you tell judges they really got to, if there's a law regulating or restricting a fundamental right, they got to have a really good reason, and it's got to be something that is an exception to the right. For example, it's reasonable not to be able to take a gun into a courtroom. It's not reasonable to pass a law saying that you cannot have a gun in your home, or you cannot sell guns in a gun show, which is Don's case. And there is another approach that the court took in the Heller case in particular. Instead of going into these doctrines of strict scrutiny, they took a categorical approach and said that, look, handguns are the primary tool that Americans prefer for self-defense. You can't just ban it. They totally disregarded these findings made by the D.C. committee that recommended passage of the bill. You know, these committee reports that go with laws like Roberti Rules or like your local San Francisco laws, they find that, guns are horrible and so many people are killed, and it's like they're trying to make findings to justify what they want to ban. And the Heller case doesn't even mention any of these findings, and the McDonald opinion has one sentence mentioning the findings of Chicago and basically repudiates them and castigates them and says that there's been a failure of the political establishment in Chicago to protect the rights of minorities and poor people. That there's so much crime in those communities, and you're telling them that the good people in those communities cannot protect themselves. So there's a total failure. It's like a failed state or a failed city, if we want to put it that way. Justice Breyer, as he did in his dissent in the Heller case, dissented in the McDonald case, basically saying that this right shouldn't be incorporated, that it should be, if it's going to be incorporated, if you're going to recognize the Second Amendment being applying to the states and localities, it should be done in a watered down way where anything goes still. So then politicians can sing, oh, what a wonderful right it is, and then they can ban all the guns they want, whatever they choose to demonize, and whatever they want to call it, if it's an assassination weapon or a assault weapon, or all the Saturday Night Special, all the names they come up with with guns to demonize them. Guess who voted with Justice Breyer in the dissent? Would this really surprise you that Justice Sotomayor, after all the things she said to the committee a couple of years back, that in fact she had decided, she was on a 3-judge panel that decided a case in the U.S. Court of Appeals for the Second Circuit, the nunchuck case. This fellow, New York State bans nunchaku, absolutely, and they arrested a lawyer who had him in his own home for working out, practices karate, good sport. And they said, well, this Second Amendment's not a fundamental right, and besides that, it doesn't apply to the states. And when that happened, by the way, I was litigating NRA versus Chicago, and I testified on the Sotomayor nomination, and I said, gee, she should recuse herself from the case. There were 2 cases consolidated, McDonald versus Chicago and NRA versus Chicago and Oak Park. And she did not recuse herself, but what did she tell the committee members? That, oh, I agree with the Heller decision, and I don't question any of that, and this is such a, I'm shocked. My favorite line from Casablanca. And now we have the same thing with our new nominee, Alina Kagan. With Kagan, we have a lot of fingerprints. I think my favorite fingerprints are the notes that she took where she compared the NRA with the KKK and was concerned that they not get the benefit of a certain bill that would immunize people who did volunteer work from liability. And my first reaction is, was that, you know, in 1871, right in the middle of Reconstruction, the NRA was founded. It's the oldest civil rights organization in this country. Guess who the NRA presidents were? I think the first 7 or 8. They were all former Union generals who fought in the war. One of them was Ulysses S. Grant after he was president of the U.S. And when he was president of the U.S., he took decisive action against the Klan for depriving African Americans of the right to keep and bear arms. Not only executive action, but signing into law the Enforcement Act of 1870 and the Civil Rights Act of 1871 that was meant to protect the right to keep and bear arms. So here we had NRA presidents who were taking, like one of whom was a former U.S. president who had fought the Klan, basically. And Kagan is comparing the NRA to the Klan. She later said in her testimony that she was only taking telephone notes from what other people were saying when she made that comparison. One of the cases I argued in the Supreme Court was Prince versus U.S. It said that the federal government could not mandate to the states, to local law enforcement, doing background checks on handgun purchasers. After that case, or before that case was decided, the Clinton administration was worried they would lose. We had argued the case. It was pending. The justices really beat me up when I argued it, and I felt pretty low, but then when they beat up the Solicitor General, even just as bad or worse, I felt pretty good. And we had a good feeling thinking we would win that case 5-4, and we did. But there's a memo, Kagan was in the Clinton White House, and she suggested that if they lose the case, if the Supreme Court strikes down this law, that the president, by executive action, can make it illegal for a federal firearms licensee to sell a gun without having a background check done. So here we've gone from the president doesn't just faithfully enforce the laws, he makes the laws. He would be making a law that the Supreme Court just struck down. And so what kind of view of executive power is that? And then we had the drafting of the Clinton import ban. There were a number of rifles determined to be importable in the U.S. as sporting rifles. They were approved by the ATF. And our great friend from your lovely state, Dianne Feinstein, wrote a letter to Clinton saying that only criminals want these kinds of guns. They were the guns that were, you know, thumbhole stocks and all that, redone cosmetically so that everybody would be happy. And so that directive was drafted by Kagan that banned all these new guns that had been just approved as sporting after the new criteria had been adopted by the Bush 1 administration that had banned previous guns that were importable. So these are some of the things that we've got to worry about. It's still going to be 5-4, and I'm confident that in the future there'll be more victories there, but it's a very tenuous situation. And one thing that we've seen twice now, when the District of Columbia lost the Heller case, they went from making life hard on gun owners to trying to make life miserable to gun owners, because then they made it a lot harder to own any gun. It used to be if you wanted to have a 22 bolt action single shot, you had to register it, but there wasn't much more to it. And now you've got to you have to take a firearm training course. You have to it expires after 3 years. You have to re-register it, or you're a criminal. You have to go through all of these gyrations and hurdles. So we have a new lawsuit pending, Heller 2 versus District of Columbia, which I'm litigating. We're in the U.S. Court of Appeals for the District of Columbia right now. And right after, Mayor Daley lost in the McDonald decision last month, Chicago did the same thing and passed a law that's trying to make it hell for gun owners even more than it has been previously. So this fight will continue. I'm very optimistic by the fact that if you go back before 2 years ago, we didn't have any Supreme Court support for our rights, and now we've got not only that the Second Amendment protects individual rights, but that it even applies in a state like California. So thank you very much.